Well, Judge Graber, good morning. Today
morning.
is Monday, August 13th, 2012. We're here in the Hyatt Regency in Maui to interview Judge Susan Graber in a brief video oral history to record some reflections on your career in the law, both on the bench and as a lawyer. My name is Gregory Fisher. I'm here on behalf of the Ninth Judicial Circuit Historical Society. This interview will be in the archives, and a copy will be provided to you for your own use.
Thank you.
Tell us, if you can, Judge Graber, how was it that you even became a lawyer? What motivated you?
Well, that's a wonderful question because I never had even met a lawyer before I went to law school. My earliest recollection of thinking about law came in the 7th grade. At the guidance counselor's office, there were a lot of little brochures that said things like, do you want to be a doctor? Do you want to be a teacher? Do you want to be a lawyer? And I read those and was very attracted to the one that said, do you want to be a lawyer? It asked things like, are you motivated to help people? Do you like to argue? So I related very, very well to that. And in addition, another early memory that had to do with my interest in the law was seeing the movie 12 Angry Men and thinking about wanting to be part of that process.
Did you have any particular role models growing up that influenced your decision to pursue a career in the law?
Not really, because as I say, I didn't even know any lawyers. I will say, though, that my parents always encouraged me to think about having a career of some kind. My other great love at the time was math, but my parents couldn't relate to that at all, so I think that probably that influenced me to stay with the humanities and non-math and science interests. But my 7th grade guidance counselor also was profoundly influential in helping me to think of myself as a professional person. Also, when I was in college was really the beginning of the burgeoning women's movement, and a lot of women went to law school at that time. Fully a quarter of my class at Wellesley, which was and remains all women, took the LSAT, which was astonishing. There had rarely been females going to law school before that. I don't think everybody went to law school, but it was a popular thing to do at that time.
And you grew up in Oklahoma?
I did.
Wellesley for undergrad and off to Yale Law School.
Correct.
And you met some people in Yale.
Be more
Bill
specific.
Clinton?
Yes.
Bill Clinton? And
Well, actually, hearkening back to college, I was in the same college class as Hillary Rodham Clinton, and we were in the same dorm, and we knew each other. And in fact, there were 4 of us who went together through 4 years at Wellesley and 3 years at Yale Law School. Hillary was one, I was one. Chris Olson, who later became the United States Attorney for Oregon, and Nancy Gist, who is an African-American woman who played a role in the Justice Department in the Clinton administration. So the 4 of us went through school together.
how was it that you wound up in Portland?
I picked Portland off the map. During my first year in law school, I was sitting with a map spread in front of me, and we had done a lot of car traveling when I was a kid. But I had never been to the Pacific Northwest, and it sounded romantic and beautiful. And I was thinking about going to Seattle, the big city of the Northwest, and one of my classmates happened by and asked me what I was doing, and I told him, and he said, well, I'm from Portland. It's much nicer than Seattle. I'll be there this summer. Why don't you go to work in Portland, and then I can show you around. And he said, go work for the U.S. Attorney Sid Lezak. You'd have a great time. So I did. I sent an application off to Sid, and I was his first female law clerk and his first Yale law clerk. and it was kind of love at first sight with Portland. I got sidetracked and practiced elsewhere for a while, but I never really gave up the thought that I wanted to come back.
And tell us a little bit about your practice as a lawyer before you became a judge. What did you do? What fields did you practice in? What did you find interesting and challenging?
I started out in my first job as a lawyer for the New Mexico Bureau of Revenue in Santa Fe. And about a year and a half later, went to work for a private firm. At the time, it was considered large. I think I was the 10th lawyer, so it was quite stunning to move into 2 digits at that time and place. And my favorite thing to do from the beginning was appellate practice. The Bureau of Revenue had an administrative hearing process after which the losing party could appeal directly to the New Mexico Court of Appeals. And so right at the beginning, I was handling appeals, and I loved that. So the firm that I went to work for was mostly a plaintiff's firm, sort of general practice. And primarily I did appeals there, but also general litigation, and that's where I began to learn how to try a case.
As a practicing lawyer, what did you most enjoy about appeals?
I love to write, and I love to do puzzles and to fit things together. So the idea of finding all the cases and finding all the statutes and putting together a coherent argument out of that and writing it down, I really enjoy that. I still do.
And then eventually from there to Portland.
Well, with a stop in Cincinnati, I was 3 years in Cincinnati working for a large firm doing labor and employment law on behalf of management.
And in Portland, I believe were with the firm that we now call Stoll Reeves?
Correct.
And then on to the Oregon bench.
Yes, I started on the Oregon Court of Appeals. I was there approximately 2 years, and then went to the Oregon Supreme Court, where I served for about 8 years.
The Oregon Court of Appeals, is that a court of general appellate jurisdiction? Does it hear all appeals, or how does that work in Oregon?
Almost all appeals. There are 3 main categories of cases that go directly to the Oregon Supreme Court. Cases in which the death penalty is imposed have an automatic and direct review. Tax cases out of the state tax court, which I think is a great anomaly. And anything to do with lawyer discipline, judge discipline, rulemaking. There are certain things that are set aside for the Supreme Court. But everything else, administrative, litigation, everything else goes through the Oregon Court of Appeals, and it has a very large caseload.
How many appellate judges were there on the Court of Appeals in Oregon when you first became an appellate judge?
10, and there are still 10. There are 3 panels of 3 judges plus the chief judge.
What was that first experience as a judge like?
Well, I loved it from day one. The person who was the chief judge at the time, George Joseph, was brilliant and a bit curmudgeonly, but he was a wonderful judge and a wonderful mentor to me, very eager to have my help, and he made me a presiding judge of one of the 3 panels almost immediately. So I really, really enjoyed it.
I'm curious, were you the first woman judge in Oregon on the State Court of Appeals? Or?
No, I was the 3rd woman to serve on the intermediate court and the 2nd to serve on the Supreme Court.
And for the Supreme Court of Oregon, I take it outside of the handful of direct jurisdiction, is it just all discretionary review?
For the most part, yes.
How was that different from the Court of Appeals?
Well, it had the same relationship to the intermediate court approximately as the U.S. Supreme Court has to us. It enabled us to pick cases not only that had important or particularly interesting legal issues attached, but also to pick cases in which the lawyers could do a good job. Sometimes we would see an issue that needed development, but we would say, let's wait for either a better factual pattern or a better set of lawyers or something like that. There's also another aspect of being on a court of last resort that I really enjoyed, and that is the opportunity to fix problems. If a tort was confusingly defined, we could say, well, we can fix that. If our cases are inconsistent, no problem, we can fix that. We didn't have to agonize over reading the tea leaves of a previous decision. We could simply take it and clarify it to our heart's content. One big difference between the state system and the federal system, of course, is the common law function which a state court has. The subject areas are very different than the subject areas we deal with at the Ninth Circuit.
And before you became a federal judge, any state cases that you presided over that you remember as being particularly significant or interesting?
Nothing leaps to mind. I would say that in general, the kind of case that I enjoyed there is the same kind of case that I enjoy here. My greatest enjoyment comes from cases involving statutory construction or the interpretation of rules, because it goes back to the comment I made about loving to do puzzles, to fit things together and try to work my way to a path of coherence from things that seem otherwise disparate.
You enjoyed what appears to have been a very speedy confirmation process, remarkably so in this day and age where there's so much contention.
Right.
How was that? What's the secret?
I'm not sure there's a secret. I think there were at least two things at work that benefited me. The first was that at the time, Oregon had one Democratic senator and one Republican senator, Ron Wyden and Gordon Smith. They were good friends. They understood working together for the good of the state. They both had legal training, although really had not either one of them practiced law, but I think they had a great understanding of the need for judges in and from the state. And that was one aspect of it. When all of this first came up, I went to visit Senator Smith, whom I did not know, and I asked for his support, and he said, I don't know you yet, you know. So he asked me to send copies of cases, so I sent him an array of cases for him to study. He interviewed people about me, he interviewed me, and ultimately he agreed to be supportive. And he was. They sat on either side of me at the Senate hearing. So I think that was one very important factor. The other important factor was that I had been a judge for a decade, which meant two things. First, it meant that anybody who wanted to know could read those dozens and dozens of decisions and say, what kind of judge is this person? They didn't have to guess, as you would with someone who's an academic. You know, do their academic writings reflect how they'd be a judge, or those kinds of questions. So everybody could see for themselves. And it also meant that I had, under Oregon's very strict ethical rules, had nothing to do with politics for a decade. So I think those things came together and made it easier. And also, I'm a moderate kind of decision maker, and I think that came through.
And the transition to the Ninth Circuit, as you noted, you'd been on the bench for the better part of a decade, if not a bit more. Were there any surprises when you became a Ninth Circuit judge? Was there anything about being a federal judge as opposed to a state appellate judge that you hadn't maybe considered or thought about beforehand?
I'm not sure it was a surprise, but it was an adjustment. As I say, the subject matter is extremely different, so I had a lot of learning to do. It was a very steep learning curve. I went from looking at workers' compensation and state tort law and state contract law and domestic relations and a whole host of things and a very vigorously litigated state constitution, suddenly to dealing with immigration law. One of my first cases was under the Lanham Act, and I remember thinking, I remember that vaguely from law school, but I haven't had anything to do with trademarks ever since then. So there was a lot of substantive learning to do. That was one big adjustment, but not a surprise. It was just an adjustment. The traveling is very different. The sitting with a whole variety of people in rotation, random rotation, rather than sitting always with the same people, was quite different also. And not having to commute to Salem was a big plus.
Sitting with different judges, different panels, did that make it more difficult in terms of the deliberative process, or is there no difference? As opposed to the state system where you're with the same judges?
I'm not sure that difficult is the right word, but it does make it different, because when you sit with the same 7 people, there are 7 of us on the Supreme Court, you really get to know everyone and how they think and how they work, and if there's a way to work around some disagreement, you have a good instinct for how to narrow something that will work for their point of view. When one sits with a lot of other people, there are a lot more personalities to learn and approaches. So it isn't harder because everyone is very forthright and nobody is shy about expressing themselves. But it does make it different than having the same players all the time.
Judge, were there any mentors on the court when you joined the Ninth Circuit who sort of showed you the ropes or helped you out any?
Well, a number of people did. The only 2 active judges from Portland are Judge O'Scanlan and me, and so he was assigned as my buddy judge. He was very helpful at the mechanics of things like, here's how you file things, and here's how I put together a bench book for traveling to oral argument, and so on and so forth. And he was very gracious and very helpful in that. I also quickly began to make friends among the other judges. There are quite a few that I count as special, but Barry Silverman from Phoenix was early on very friendly and very helpful to me, and Judge Kaczynski also, a number of people.
Any particular cases stand out as being particularly challenging or interesting that you've worked on as you started your career as a Ninth Circuit judge? Let's confine it to maybe the first 5 or so years.
Nothing leaps to mind.
And broadening it out to the present, any cases that you can think about that you've really enjoyed working on, or?
Well, it's a little bit like asking me to choose among children. I only have 1 child, so that's actually easy. But it's oftentimes the one I'm working on now that I find the most interesting. I get very involved with that process. I suppose the ones that are at some level interesting beyond the statutory construction ones I was talking about are those that raise constitutional issues, or those such as the Al Haramain case that I wrote some few months ago that get a lot of public attention. So that's always interesting to see how something is portrayed that you've worked on.
A number of us students of the court, and I count myself in that number, perhaps immodestly so, I've seen you've had a remarkable degree of success in writing opinions for the court when it sits en banc, and in collecting consensus. How have you managed to enjoy that success? Is it something that just comes naturally in terms of your ability to work with different people, or is there a skill or an art to it?
I'm not sure I'm the best one to answer that question in terms of how or why it works when it does. I think that one thing that helps is that I'm very good at keeping people's confidences, and so if someone wants to talk to me privately about something, anything, whether it's work-related or not, I know how to do that, and that's helpful in gaining the trust of my colleagues. Also, I'm not ideological. I don't view myself as being in any particular camp. or being necessarily predictable in some kinds of cases at least. And I think that helps because I don't have an agenda, and I think most of my colleagues know that I don't. If I have an agenda in the en banc process, it would be perhaps two things. One is sometimes we have conflicts in our precedents, and those are cases that I'm very interested in straightening out. Not necessarily in how they get straightened out, but just making it clear for the future. And the other is, I think, a holdover from the culture of the Oregon Supreme Court, where we really hated plurality opinions. We felt it was our obligation to make a rule of law. And people were willing to narrow things and be conciliatory in the interest of getting some clear rule for people to follow. And I've carried that thought with me. And so I have a bit of flexibility in the interest of obtaining a majority for something, which doesn't mean I'm squishy and I'll just give up anything. But I do think I'm very conscious of trying to make sure that there is a clear rule of law in each case to be followed. I mean, that was one of the other things that was different, of course, no longer being on a court of last resort, is we do have to read the tea leaves. We do have to do our best to interpret what the Supreme Court has instructed us to do. And so the playing room is narrower.
We have a new Ninth Circuit judge in Alaska,
yes.
Morgan Kristen. Have you had a chance to meet her yet?
I have. She seems quite lovely.
We're going to miss her from the Alaska Supreme Court, but we were thrilled that she's going to stay close at hand as a judge. I think her chambers are going to be in Anchorage. Would you have any thoughts or ideas or tips for her as she starts out on the Ninth Circuit?
Get to know as many of your colleagues as you can on a social level. Break bread with them. Be willing to rethink your position in any case when presented with the opposing view, because everybody on the court is smart and they have a reason for writing or saying what they have. Give yourself some time to feel confused. When I move to a new city, I always give myself a year to get lost. And in a sense, I did that on the court as well. I felt, well, I really won't know very much for a year. So I gave myself permission to ask a lot of questions and not know very much about any given subject. I had to read dozens of cases in new areas of law and just be a little bit patient with that process and just sit back and enjoy it. It's a fabulous job.
You, having been an appellate lawyer and having loved that as a practicing lawyer, now that you've been on the bench for these years, do you ever, when you're presiding over a case, do you ever want to kind of have the temptation to step in and sort of tell the lawyers how to better argue their own appeals, or?
Well, I try not to do that because, of course, we're limited by the arguments they actually do make. There's a lot of Monday morning quarterbacking on the court where when we discuss a case, we think, oh, well, they could have done this or they could have done that, but it's not very helpful to do that. One big difference from being on the other side of the bench is I'm no longer nervous before oral argument, which I always was, no matter how many times I did it. And the other thing is the freedom to look for the right answer and not the answer that you are having and wanting to argue on behalf of a particular client. So it is quite a different experience being on the other side, but I still appreciate what the lawyers are going through and try not to be too hard on them when I can help it.
Is there anything you'd like to share with us that we haven't discussed already?
Not really. I just very much appreciate the opportunity to chat with you, and I'm looking forward, I think, to seeing what my colleagues have to say about their lives, too.
Well, Judge Graber, thank you so much for joining us this morning to discuss your career.
Thank you.